Welcome to Realty Success. We're so excited to have you all here with us this week. We're speaking with a real estate attorney who's going to talk to us about backup plans in real estate. What if something goes wrong? Believe it or not, it does happen sometimes. I'm Brooke Bryant. I'm a realtor in the Charlotte, North Carolina area. So happy to be with you all here today. And we have joining us Angela Brown. Angela, will you say hello to everybody, please?
I will. Hi, everybody. I'm so excited to be here. I am the move in, move out cleaning part of every real estate transaction for buyers and sellers. So I'm super excited to be here on this podcast today. And today we've got a great show for you.
Aaron?
Yes, I'm a realtor out of San Antonio, Texas, and an author. So happy to be on the show today and really looking forward to it. Thank you so much for having me.
So glad to have you here. And Regina?
I'm Regina Brown. I am also out of San Antonio, Texas. I am a realtor here who specializes in the luxury real estate market. So anyone looking to buy or sell in the luxury market, I would love to help you. So please reach out.
Thanks, Regina. And our guest expert today, we're so happy to have you with us. It's Liz Barletta, and she's a real estate attorney. She works in Boston and in Florida, and she's going to talk with us today about having a home buying backup plan. So welcome. Thank you so much for joining us.
Thank you so much for having me. I'm super excited. This is a really interesting topic and one that I encounter a lot. So I'm super excited to be here. Thank you for having me.
Well, before we get started, could you tell everybody a little bit about yourself, how long you've been in real estate and what drew you to this industry?
Yeah, I'd love to. So I'm Liz Barletta with the Barletta team at Ligris & Associates out of the Boston area. And I was drawn to real estate specifically because I'm the daughter of a realtor. So I spent my weekends at open houses and, hearing about how sometimes real estate attorneys aren't the most popular people in a real estate transaction. And so once I gravitated towards the law, I found in Massachusetts particularly, a real estate attorney is heavily involved in the transaction as opposed to some other states. And so it was just a great opportunity. I already had a love of real estate, knew a lot about it from my mom and all the things that she didn't like about real estate attorneys. And so it was just a great opportunity for me to grow in that field and really always have her in the back of my mind to make sure the client experience is as great as it possibly can be, and things that again, she wasn't the biggest fan of. I really try to tailor to make sure that the client gets a great experience while being represented in the right way.
That's fantastic. What a great reason and a great why to get into this industry. And we appreciate you for that as realtors. Most of us are realtors, so we really appreciate that.
We do. And Liz, it seems like sometimes things unexpectedly can go wrong during the buying or selling process. From your perspective, maybe you could tell us a little bit about that.
Yeah, so it's interesting. I had a transaction actually this morning that had an unexpected issue. So it was proper timing. Me and the client had a good laugh about the fact that we had this podcast airing later. They gave me the great example. So one example in particular, when buying a home, there's a lot of nuance to lead up to what ended up happening at the closing table. However, in Massachusetts in particular, part of our job as an attorney for the buyer is to research the title. And our standard in Massachusetts is a 50-year title search. So we're going through the history books at the Registry of Deeds, researching to make sure that there's no clouds on the title or title issues. So basically making sure that the right seller's selling to the buyer, that any mortgages that are outstanding have been satisfied and released with proper documentation, making sure the seller hasn't been sued or there's past due taxes. All those things go into our research of the title. Well, in this particular transaction that was closing today, unfortunately, there was something that the seller wasn't able to take care of in time for our closing day, which was today. So we had to sort of go into, emergency mode because people had movers, people had plans and contractors coming. What can we do? How can we still achieve the closing and get the closing completed? And so again, that's something that happens last minute, unfortunately, because the seller's attorney, there was something that he didn't follow up with. And so that kind of led to not having something that we needed for closing. But when something can or does unexpectedly go wrong at the closing table, there's usually a way to still make it to a closing. At least in Massachusetts, we try to figure out a way to still accomplish our goal of closing that particular contract date. So in this particular case, we had something that wouldn't necessarily make our title what we call unmarketable. So it was still a clean title, but it was something that we wanted to be cleared up. It was relative to a permit. And so in order to still close, we were able to hold back some money from the selling side for the buyer to feel comfortable that the seller would complete this task post-closing and still close and have the contractors come in and do all the things that the buyers really wanted to do today. So that's one example of sort of something unexpected that could happen. Even on a closing day, no matter how hard we try to make sure everyone who has their job does their job the right way to get to that table, sometimes these things happen on a last minute basis, but usually there's a solution. And that's sort of what our team is always, our approach is trying to find the solution to make sure the client feels comfortable, but also meets their goal of closing.
When those things come up, do you find that it's typically on the title side or lending side, or is it?
Great question. So we see it all. We definitely, so in terms of last minute things, they tend to be either title related. I mean, they could be title or lender related, to be honest. Most of the time, lender related issues though tend to, at least since the sort of the change in law several years ago with TRID and closing disclosures having to be sent out in advance of closing, oftentimes that has resolved some of those lender issues where we're not necessarily finding out the day before. But even in some situations, we've seen, unfortunately, someone finding out that the lender finding out that the title, I'm sorry, I lost everyone on the, maybe I just changed.
There you are.
Sorry, never mind. So it could be that there was, a charge made on a credit card last minute, or something like that could potentially affect, because the lender is required to do a last, credit check to make sure that there's no issues on the credit end. So we've seen things like that are sort of lender related, last minute issues, but generally I feel like it's a matter of documentation from the selling side, at least in Massachusetts, that we feel like tends to be the reason why there's like a delay in closing or something unexpected like that.
Yeah, no, that makes sense. I had one where we were not told that the woman purchasing the home was married. Her husband was in Dubai, and she never said she was married through the whole process. And we got to the closing table, and turns out she's married. And, of course, it delayed closing. We couldn't close.
Right.
Title and lender said, no, we can't move forward. And she contacted her attorney to try to get that figured out. What do you recommend in a case like that? Is that a case for an attorney?
Oh, yeah. So, I'm coming from a perspective where in Massachusetts, it's very typical for attorneys to be involved. Our legislature has found that the conducting of a closing is the practice of law, whereas in other states, a title company handles it. So it may not be a situation where you always are interacting with an attorney, but it's very common in Massachusetts to always have a buyer's attorney or have a seller's attorney. There are, of course, situations where you may not necessarily have one on the selling side, or even if the buyer chooses to not to have their own personal attorney, but there will still be a bank attorney involved. So from our perspective, it's very typical from the onset to have an attorney in the transaction from the get-go. But at that particular, for those in other states, that is 100% a situation where you want to get an attorney involved, because they'll just think potentially of outside of the box ways to make it to the closing table. I actually had a similar situation, but on the buying end, where I had a client who I didn't realize was actually in the armed forces and was stationed abroad. He was the one who was interacting with me all the time on the transaction. I would talk to him on the phone. I never had an idea that he was outside of the country. And when his wife came to closing, I was like, where's your husband? And she's like, oh no, he's stationed, you know. And thankfully, we had a lender that was able to work quickly, and we got a power of attorney that the most armed forces members have approved within the same day, and we were able to still close, and the wife signed. But you know, there are things that just you can't anticipate. You know, I always talk to my husband about the fact that we need to write a book of all the crazy tales that we've encountered in real estate in particular.
Oh, absolutely. So those were great examples on the buy side. What about on the sell side? What are some good examples on the sell side?
So on the sell side, you know, I think really title issues, again, I feel like it's the answer is always title or lending. From a perspective of seller, oftentimes it's a situation where you may not realize that a title issue existed. And if when you purchased the property, it wasn't sort of in fashion to have title insurance, that could pose a problem. So we had, I had a client actually who was selling their property, and they had been in the property since the 80s. And they didn't realize, obviously they wouldn't have necessarily remembered from back then, but the person who represented them in the purchase apparently didn't do a great job in their title research. And so, as I'm sure you've encountered, sometimes when there's family transfers, so father maybe transfers to a son, and the son transfers back to the father, and then to a trust, and then back and forth. And sometimes that happens where within the family, they're sort of the title of the property is transferring hands, but if you're not doing it the right way, that can obviously be a problem. And so in this particular lady's situation, she was selling a house that she'd been occupying and owned for, at that point, 30 years. And the buyer's attorney, when they did their research of the title, found that she only owned 50% of it. And that was because there were transfers made, and the proper person wasn't added to the last deed that went to her.
Oh no.
So yeah, which was, you know, it could have been a lot worse. I have to say it was pretty bad in the situation because she was trying to sell. She was already under contract to buy something in cash. So she had no contingencies just to protect her. And thankfully her seller was able to be flexible with her and extended closing. So it could have been a lot worse. But in that particular situation, I became kind of like a PI, a private investigator. I was trying to find these people because at that point, everyone had kind of passed away. And so they were heirs of this family. Thankfully, they had a very unique last name. And I was able to find one family member in Tampa, one was in Connecticut, and one was in California.
Oh my.
And they didn't ask the seller to pay them anything. They were just kind enough to sign the deed for that 50%. So she was able to, I mean, she was incredibly lucky because any other situation, you know, people are human. You find out magically that you own 50% of a property in this case, it was Somerville, Massachusetts, which is a very highly desirable area with really high price points. And they were just kind enough to transfer it to her. And so she was able to finally sell the property.
Nice.
But yeah.
At what point do you get an attorney or title company involved in a situation like that? I'm dealing with one very similar at the moment.
Mm-hmm.
And they're curious on who they need to bring in to facilitate that.
Yeah, I mean, I would say the moment you have an inkling that there's some kind of problem or some kind of issue, it's important to contact a real estate attorney. Just because they may be thinking of a way to, you know, strategically find a solution that you just may not have encountered before. So I think that especially in situations relative to title, anything related to even financing and contractual like interpretation, you just really need to contact an attorney right away to be able to guide you through that process. Because at the end of time, you know, time is money. And oftentimes, especially with real estate transactions, if there's delays, someone's paying for a rate lock extension. If there's, you know, if you're going to lose the deal, maybe you're going to make less money on the next one. So it's just important to have someone, you know, aligned with you at the onset, I think, of any kind of issue like that, just so time constraints are sort of alleviated.
So I got a question for you, and this is the devil's advocate part of this conversation.
Sure.
Let's suppose that you're an attorney in the room and you've got a realtor for the buyer and a realtor for the seller and a seller and a buyer, and you're all in this room together and a deal goes bad. Like, I don't know, somebody only owns 50% of their property. How do you manage the emotions in the room at that point?
It's tough. It's tough. I think one of the things that I like to think kind of sets me apart as an attorney is I have a lot of empathy. And I think it's so important for you to be able to connect with not only your client, but the other side, and think of the other perspective. Because if you're able to kind of think about the other side's perspective, the likelihood is if you're negotiating a point, you're going to be able to propose something in such a way that more likely than not, they're going to be able to accept, because you've had that step of thinking about their perspective. I mean, COVID's kind of changed things in a sense where those types of closings don't happen very often, especially in Massachusetts, at least. The likelihood of having everybody in a room is kind of a thing of the past now. Most closings are done separately, where the buyer's meeting with their attorney and the seller's kind of on doing things in advance of closing with their attorney. But in back in the day when those types of things would happen, it is definitely difficult, and it's really a matter of managing those kind of relationships and the expectations of the clients, and always keeping in mind the shoe on the other foot, and really trying to keep that sort of top of mind, because that likely will be the way that you're going to kind of get the end result in a positive way.
We talk a lot here in our group in Realty Success about how important relationships are and what a big part of real estate relationships are with the realtor and their client, and the realtor and all of the people that are involved in the transaction, real estate attorneys, lenders, all the moving parts. I'm in North Carolina, and we do require attorneys close our real estate transactions. And it's so important to hear what you say about being empathetic. It's such a huge and emotional transaction for so many people. And I've seen more and more of that, of all parties being, okay, let's make this a situation where everybody wins, and a big push towards that. I'm in the middle of a transaction right now where there was one party that just wasn't, they were hard to navigate this transaction with, and it really does put a snag in things. So what do you do when you're in a situation like that, where you're dealing with so many people as the attorney, the buyer's agent, the seller's agent, the lender, surveys, all of that? So how do you manage all of those different personalities, not at the closing table, but just throughout the process?
Yeah, no, it's definitely a challenge. It's one of those, but so thankfully I've built relationships with all, the agents that I work with and the lenders that I work with, the people that sort of are on our side of transaction. Everyone kind of knows how each other works, but there are things that, throw a wrench in anything. And so it's really important. Team and I, we have meetings, weekly to talk through situations and what's going on in our transactions. And a lot of the part of the sort of the vast majority of our meeting is really talking about, so what is happening in this transaction? How can we alleviate some stress? Or, so I think it's really about preparedness, and also kind of really knowing who you're working with well, and sort of what's really going to achieve that goal, and bringing people back to reality. I think I like to get on the phone in a lot of situations versus everyone's emailing or texting. And especially, we get so many emails a day. It's just easy to be robotic about replying to an email, but sometimes you just need to pick up the phone, and you have to have a conversation on the phone with the other side's attorney or the other side's agent, or whatever the case may be, to get your point across in a way that, sometimes emails don't come across the right way. I know it happens to us. I know we read sometimes things into emotions into certain emails that may not be there. So one of the things we always try and do is, try and be aware of those types of situations and talk about that as a team and say, hey, this seems weird. Like, we've interacted with this attorney before, but they're their position is off right now. Like, what do you think it is? And we kind of brainstorm how to best approach that particular person. Usually it's picking up the phone. Let's pick up the phone. Let's have a conversation. Like, this is what we're trying to achieve. What are you trying to achieve by talking in this way? Or, being very firm on this point. What's your goal here? And usually being very blunt about that while being respectful kind of puts people back into focus, I feel like.
Quick question on that. And regarding a third party, we had a situation where an appraisal company pushed the appraisal out almost 3 months on a 30-day closing, and then refused to produce the appraisal document. And so we ended up at almost 4.5 months before we could get the appraisal back. And according to the title company and lender, we just have to wait. Is there something legally that can be done to prevent those kinds of things from happening? And at what point would it be appropriate to bring in legal counsel to consult on a situation like that? It almost ended in a divorce because of the stress of a double contingency and waiting on an appraisal on a jumbo VA loan. So lots of complications on that one. But I'm just curious from a legal perspective, what I could have done in retrospect. And if I ever face that again, what would happen legally, and what action we could take as a realtor or even as a lender or title company to say, hey, something needs to be done,
Yeah, no, I mean, that seems just not right. I mean, obviously I don't know the laws in Texas. I don't know sort of what your contract looks like in terms of, what nuances, what contingencies or anything like that. But that just seems not acceptable in any stretch of the imagination, even besides the fact that like legal or not legal, it just doesn't seem like there would be a contractual way for them to just, as a third party, say, I'm just going to delay your closing, or at least, not provide you what's necessary in order for the closing to happen on time. I mean, if that's the kind of response you're getting from a third party appraiser, I would think that, in the future, maybe this is already done, but like contacting the company, not the appraiser themselves, but the company that they work for, and say, what is this protocol and why is this acceptable? And if not, then have the lender assign another appraisal company. I don't know if that was done or not, but that just doesn't seem like it just doesn't seem right.
Yeah. So here in Texas, typically attorneys don't get involved in a real estate transaction unless there is a need for an attorney, so to speak.
Litigation or something like that. Yeah.
And in this particular case, the lender said, we can't pick the appraiser. It goes out to a third party. Someone has to pick it up. We just have to wait. There's nothing we can do. Our hands are tied. We're really sorry. It was a double contingency. And so, families on 3 different families basically were affected, and everyone was frustrated, of course. And at the end of the day, lender just said, there's nothing that can be done. We just have to wait.
And is it particularly busy time in Texas in that particular market because what we are seeing in mass is sometimes appraisals are delayed because there's just a lot of volume. Was it a volume issue, or was it just like we don't want to get to it?
In this particular case, it was a jumbo VA loan just outside of city limits. And so they were waiting for an appraiser that could do it. And it just took a long time to get picked up. And then the appraisal company wouldn't produce an appraisal. They just wouldn't produce it. And so we just kept delaying and delaying and delaying, a week at a time, 2 weeks at a time, a week at a time, on all parties, have everyone sign off on it. And again, everyone was saying, let's get attorneys involved. It's affecting too many people. And again, no one really knew what to do. Even the lender was like, we don't know.
Sometimes
know what to do.
When you never see something and like it's completely out of sort of the norm or the realm of like what seems to be reasonable. I think that's definitely a moment of like reflection, saying maybe if this seems outrageous, especially if it's a state that doesn't have attorneys generally involved. I think one of those moments, it seems like an attorney could have potentially helped. Maybe not, but at least sometimes phone calls from attorneys have sometimes magical powers.
Well, next time we will get them involved right away. So, okay, thank you so much.
Yeah.
Well, and with that being said, what are some of the most common hurdles that people are unprepared for?
So I think it really depends on sort of the team that's surrounding a person. But what I've seen over the years, and like a lot of the feedback that we get from clients who've been involved in real estate closings before, is expectation setting. I think that if hurdles that generally come up to sort of affect a transaction are really only hurdles if the client doesn't know about them.
Of course.
If they know that something is potentially going to happen, they can plan for it in their mind, so it's not a problem. So I think that the big focus for us always is to manage expectations, but also to set those expectations so we can exceed them. Because at the end of the day, we want raving fans and all that stuff. But at the end, it's so important for clients to know that, yes, from a lending perspective, like don't open new lines of credit. Like from a title perspective, from our state at least, expect that there could be something that could postpone closing. From a seller's perspective, when you're accepting an offer that has a contingency for financing, that financing may be denied and the deal may terminate. So don't necessarily pack all your bags, but you also want them to be packed at the same time. So it's
Absolutely.
it's definitely a dance sometimes with those types of things. But setting the expectation of everything that could I always sometimes feel like I'm like the bearer of bad news, but I always try to do it in a positive way. But for me, I always tell them, I'm telling you all the things that could potentially go wrong. So that way, when they don't, you're like, this is the best transaction ever. But also, if something does happen, you're prepared mentally for it and you have a plan.
Yes.
Because the worst thing that could happen is if you just don't anticipate that someone's going to terminate as a seller for financing, and you had your other purchase contingent, not contingent, for example, and now you can't buy, you can't sell. It's, super stressful. Or if you're a buyer, and at least in our state, if there is a title issue, for example, that comes up, the seller generally does have the ability to extend closing unilaterally, meaning they don't have to ask the buyers for permission to resolve a title issue for a certain period of time. If the buyer doesn't know that and they have a closing September 1st and they have to be out of their apartment August 31st, and now that seller's extending until September 15th, where are you living for 15 days? So we
Airbnbs.
Airbnb. There you go.
Not that we've ever been down this road.
Yes. I mean, but thankfully, having that conversation in anticipation of that, high likelihood, especially when you have that like rental to buy, it's tough. When you have such a tight timeline, I should say.
We're dealing with a lot of contingencies in our market right now.
Mm-hmm.
Do you recommend just getting attorney involved right at the onset?
So as an attorney, I feel like I like to always advocate for our usefulness. But I think it's important for the client to understand. I think as an agent for in a marketplace that an attorney isn't required, your client usually pretty well. And there are certain clients that I feel like always could do well with having a second perspective involved in the transaction, or explaining something in a different way to a client to make sure they understand. So sometimes for some of my colleagues that work in other states, I often I will recommend attorneys involved for those people that they know. It's kind of like a insurance policy for yourself as an agent. If you have that kind of particular client who's asking all these questions, maybe you feel comfortable answering them because you know the answer. But sometimes I just feel like if things get a little bit too detailed or maybe they're concerned about things that are kind of out of the ordinary, it may be a good idea to at least recommend an attorney so they can explain it potentially in a different way.
I like it. That's great advice.
Thanks.
Angela, you were going to say something. I saw it.
I didn't want to interrupt. So my question is then, if you are a buyer and you, in a perfect world, there's only plan A, but how do you anticipate a plan B so that in the event that something malfunctions at the last minute, you're not left without options?
Yeah, and that's the expectation of what if the deal falls apart because of financing or a title issue, where are you living? So that's, I think, so long as housing is kind of solidified, what I hate is those situations where like, I'm going to be homeless. What am I doing? Like, where am I going to live? I have 2 dogs that maybe, you know, another rental won't accept, or I have children that were supposed to start school, or, you know, having the backup plan of the expectation that we may not close on time. And if you have to vacate where you are, where are you going? I think if you have that solidified, everything else can work itself out. But where are you going to be if something like what will happen? Where are you putting your family and your where are you putting your family more than anything? I think is the biggest hurdle in a transaction that could potentially fall apart.
Okay.
I've recently had 3 transactions. All of my clients were local and had places they could go. One of them, and it's so amazing, right, guys, how things do happen right at the last minute. Closed on the house. They go to move in. A pipe burst. The home had been fully inspected. Repairs had been done. It was a big garden tub that the sellers had never used. The buyers were going to give their little ones a bath in it. It burst. No fault of anyone, just burst. Second one, in North Carolina. I'm not sure if it's the same where you guys are, but you're not supposed to give the keys until the deed records. And the buyer and the seller saw each other out in the hallway, and the seller gave the keys. The buyer starts having hardwoods put in. A pipe got cut and burst. And a third, there was just a delay from a lender, and it was a contingency, a back-to-back closing. But all 3 of those, luckily, they were local and had backup plans of their own. But hearing this, I'm definitely going to create a backup plan for my realtor toolkit and create what if scenario. And here's a list of hotels that will take your dogs, that are convenient, that can accommodate your moving truck. I'm definitely going to add that to my toolkit.
That's a great idea, because you know I don't know about your marketplaces, but at least in the Boston area, I feel like more and more there are title issues, there are lender issues, things are getting more with the rates, how they are right now. I've seen more denials than I have in a long time, just because, you know, you're getting close to, you know, debt to income, and then the rate maybe jumped a little bit and now you can't follow. So I've seen a lot more of that sort of turmoil, unfortunately, with transactions where we're trying to save deals more and more. So having that backup plan, that's a huge benefit for your clients, for sure.
Thank you for that tip.
Yeah, absolutely. And actually, one thing to mention, again, everyone's from a different marketplace. So in Massachusetts also, you're not to give keys until the deed is on record. And that's similar, also adds to the sort of a little bit of a chaos at closing, where you go to a walkthrough, you know, things are still dirty or not moved out, and, you know, but you need to get to record. And because if you can't get to record, then the movers can't come that are on their way. So another level of kind of stress around a transaction, where we do a lot of what we call holdbacks, or holding back funds from sellers for situations like that, so that the deed can go to record and keys can get released, but things that the seller didn't accomplish can still get paid to complete them later.
Well, and I think that's great too, to hear the creativity that you bring to the closing table, because there are so many last minute things. I try not to do the walkthrough the morning of, but you never know. To do the walkthrough and some of the repairs weren't completed or weren't completed properly. And you have to do, but everybody still wants to close. So for you to have the creativity to still make that happen, but to come up with a solution to ensure that the repairs are done and that all parties are made whole. I think that's really important to have somebody working with you who can make that happen.
How typically is that written up, by the way? Let's say that there's some sort of holdover money. Does it get returned after it funds or?
Yeah, so we, attorneys love paper, attorneys love to draft documents. So we just slyly add another document to the pile of 1,000 pages that you're already signing with the buyer. But we do negotiate usually a document that will be very clear as to what the obligation, let's say it's a seller obligation that needs to be completed. We put it very clearly what that obligation is and how the money gets released as a result of that. So for example, we usually will have a time limitation. So if it's, let's say, the movers haven't finished and the seller still has stuff that needs to be removed, maybe we'll have 2 days after closing, the seller has to have all of those things completed. We'll hold back a certain amount. My office will control that money. And then once we hear from the selling side, yeah, everything was done within the time frame, beautiful, we release the money once our buyer confirms that. But if they didn't, then usually in that document, we'll have again, we like to think ahead of what could potentially happen. So oftentimes people miss deadlines. So if they miss the deadline, what happens? Well, then the buyer, for example, could hire a junk removal company and they submit an invoice, we pay it from the holdback funds. Once everything's out, anything remaining goes back to seller. So we try and negotiate that with the seller's attorney. Again, just to set the expectation. Our contract in Massachusetts is a 2-part contract where you have an offer that's sort of bare bones, 2 pages long, and then a secondary purchase and sale agreement, which is similar to what most states have, which is much longer with all the contingencies. So in those contracts, there's so much that doesn't apply to a deal, hopefully, because the deal will go smoothly. But attorneys try to, anticipate things that could go wrong and put it in black and white at that moment. So that way, in the future, if something were to happen throughout the transaction, we can just point to the writing and say, well, this is the process. So similarly with an escrow holdback agreement, we do that, where hopefully they abide by the timeline. And if they don't, then this is what happens.
Interesting. Yeah,
So,
in your states
go
too,
ahead.
if you do hold back funds, I'm just curious, is it mostly like a verbal thing?
I guess it's dependent on the situation and how much it would constitute.
Right.
I just had a situation where I had a seller who I was representing, and they were moving out of their home. They were purchasing a ranch. The ranch was closing later, but they wanted access to the barn to move stuff into.
Mm-hmm.
And the seller of that property didn't want any legal obligation from that person coming onto their property and or getting hurt. And then they also wanted a holdback of money in case there was any damages prior to closing that would then be returned at closing. And so they put it upon my shoulders to come up with a monetary amount of if some damage happened, what possibly could go wrong and how much would that cost. And because it was access to a ranch and they were just getting access to a barn, the only thing I could think of was either the gate, the electronic gate being damaged in a move, or the barn door itself. And so we did $1,000 holdback and then had an attorney write up a hold harmless agreement that they wouldn't sue if they were to get hurt on the property between the time of execution of that and close date. In order to make that happen. And so I'm curious from an attorney perspective, how you come up with those values, because it was very arbitrary. I didn't know what kind of monetary price to put with something like that. And if a gate goes out or, then so how does an attorney calculate those kinds of things in terms of monetarily, this would be the right amount?
It's a great question, and it's a challenge. Obviously, every situation is so different. Even town by town or property by property type is so different, and given the situation that it could be. But I usually rely heavily on my realtor partners, and in their, our junk remover partners, our people, all the people sort of in our realm of within our sort of area to see, like, if worst case scenario, this were to happen, like, what's the potential cost? But besides the potential cost to replace, there's also like the emotional protection for a client. So the client in particular that I had the title issue this morning with, we ended up asking for a lot more than would probably be necessary, but mostly because it was like an emotional thought process, like, let's make it this amount to really induce the seller to do what they need to do quickly. So sometimes it's not necessarily even like replacement cost or cost to fix. It's like that emotional value that really ends up contributing to sort of how we negotiate those agreements for holdbacks and different sums of money. What we also try when we're on the buying side, not so much on the seller side, we try to delete these types of paragraphs, but we try and keep the seller responsible over and above the amount that we're holding. So at least worst case scenario, if we did a bad job estimating what it could cost, the seller is still on the hook contractually. They'd probably, if they didn't want to pay it, they'd still, the buyer would have the ability to, sue them in court, which would stink to have to go through that sort of hoopla for that type of thing. But at least they have something in writing signed by both parties that could keep the seller responsible if whatever cost exceeded what we ended up creating for the holdback.
I'm curious how that would work, or how that's worded.
Yeah, so basically saying that in the event that the cost associated with XYZ exceeds the amount of the holdback, then seller's responsible for any, like, essentially like a delta, like whatever difference there is.
Fantastic. That's brilliant.
Yeah.
I don't know how you all get through real estate transactions without an attorney. There's always like survey issues. There's an outbuilding that goes beyond the survey boundary, or there's always something. We rely so heavily on our attorney partners and their support staff. I'm sure it works very well. It's so strange, right? All these different markets and how they operate.
I don't know that it works that well, because we need them all of the time. And that's why I have so many questions. Half of the deals I work with, I'm like, oh, we should have an attorney on this, and everybody's like, oh, attorneys are expensive. Let's just figure this out. I'm like, it's a big purchase. Yeah. You should get an attorney,
It's not that much here. Yeah. It's not that.
In comparison to the property, it's not,
Right.
For
Well,
the type
and it also depends, I think. So I think the states that have attorneys that are required to be as part of the transaction, those attorneys, I mean, including myself, we really work to become affordable and not what most people would consider, like, when you think you're going to hire an attorney, there's a retainer involved, there's hourly fees. Well, I don't want to call this attorney. I'm going to get a bill that's, crazy. We don't do that, at least in mass. The majority, some attorneys do. I mean, everyone can do their own thing. It's not like mandated to fee a certain way to clients, but we always charge flat fees. And the majority of people who are attorneys who practice solely in transactional real estate, not litigation, but transactional real estate, are generally flat fee service versus other areas of the law that would have those sort of. But what I have heard from other states that don't require attorneys is they don't have flat fees, and they are hourly. They have like sort of the way that one would think attorneys charge. So
yeah, typically a retainer, and sometimes you can hire them for a one-off, like we did on this last deal, where we hired them just to write up a hold harmless. But even so, I mean, it was, I think, like $500 or $600 for them to just write a hold harmless agreement. Right. It was a paragraph.
Which that could be the representation fee for the entire transaction in a state of, like, in Massachusetts, for example. We get paid in other ways, title insurance and things like that. But generally that could be like the fee for the entire transaction. So
I'm dealing with a couple of probate issues at the moment, and
Probate?
probate. And their question to me was, should we get an attorney? We feel like they're very expensive, and can title handle the probate versus an attorney?
Right. Well, state by state, obviously, I don't, at least in Massachusetts, I do transactional real estate. I do not touch probate. I work with my probate partners who do their thing and I do my thing. We all live in our own little bubble because, well, for my own personal practice, I like to be responsive to clients. And when you're in probate or anything litigious, you are in court all day. You're waiting for your case to be heard and you're just not available. So oftentimes, at least in our state, you find that most attorneys who are real estate attorneys do only transactional real estate. Those probate attorneys do their own thing. And so, I don't know how a title company would necessarily handle a probate. I don't think that would be something they do. So the likelihood is that they should definitely hire a probate attorney, especially because in our state, for example, depending on how the will is written, you either have to get what's called a license to sell, or you can just sell. The personal representative can just sell so long as they have that right within the will. So there's just nuances that a title company, I'm sure they're able to like read the will and decipher those types of things. But the likelihood is in your state, it would probably make more sense to hire a probate attorney.
So in this particular case, so it's the daughter, and her father had put the property in her mother's name. 6 lots. He put 2 of them in the mother's name. 4 of them are in his name, and then he passed away. He didn't have a living will or testament. And the daughter believes she has right to the property, and her mother is no longer of sound mind.
It's so tough.
Fun times.
Yeah.
I was like, I think we need an attorney for sure.
Yes. For numerous things, because at least, again, I don't know the laws in Texas, but like you have to have the court appoint a guardian essentially, or power of attorney for the mother who's not of sound mind to be able to properly transfer title and have, because she can't, these are things that title insurance is for example, because if someone notarized the deed from the mother and then it's later found and contested that the mother was not of sound mind, that's what title insurance can protect you with. But because the notary won't necessarily know truly if someone's still talking to them and saying that they know what they're doing, but then maybe is truly of not sound mind. So anyway, that's a little bit of a tangent, but I think that for sure, a probate attorney is super necessary because they're gonna need somebody to appoint someone for the mother to properly transfer title, and also the father, if he didn't own it in a trust, which I'm assuming he didn't, and if he owns it individually, then
he owns it, and he gave it to his daughter supposedly, who's going to split it with 6 siblings.
Oh gosh.
But she doesn't want her siblings involved until after the transaction is completed. And so here I am going, let's get an attorney, and she's like, I think the attorneys will be too expensive for this. They're just lots. Can we just put it on the market and sell it as is? And I'm like, how? Without chain of title being in order.
And who's signing for that? Who's signing the deed? And these are the things too that later, it's interesting sometimes how clients can be, because she wants to sell as quickly as possible, but what's going to delay this is when the buyer's title company researches the title and says, you need this, this, and this. Well, you just wasted, a month with this particular buyer and you can't perform potentially. It's just, I think it's always better to nip it in the butt and do it sooner rather than later, because it's an inevitability.
Liz, I love what you're saying. Thank you so much for that. I will recommend you get an attorney right away.
Yeah.
Now, in North Carolina, we wire the funds through the attorney's office, and then the attorney distributes the funds at closing. So the lender will send the money to the attorney. And there's a big concern and a big effort to make sure that there's no wire fraud committed. Are you seeing that?
Oh yeah. So in math in particular, we're seeing a lot of law firms actually not wanting to take wires or send wires, I should say. They'll accept the wire from the bank and from the buyer, but they don't want to wire out anymore. They've gotten to the point where it's just so, I mean, we have an attorney, a paralegal in our office. All she does is, send out wires, receive wires, like stock our accounts, making sure that nothing is fraudulent. So it's a big expense for a lot of offices, especially if you're a solo practitioner or you have a small operation. Those costs are very, very expensive. And so a lot of these smaller firms are just saying, no way, I'm not wiring. You can come pick up the check. The only situation that they usually will accept wiring is if they're wiring to another law firm for like a subsequent purchase, for example. But if not, they're not going to take the risk. It's interesting though, because also some offices of attorneys won't accept certified checks. I like the certified check to come to closing with because it's physical, it's in your hand. I don't have to worry, and I can tell my buyer, just get the certified check. But also in Massachusetts won't accept that either. They're requiring a wire transfer for the funds. Our title company in Florida will require a wire transfer because there's been so much fraud with certified checks. So I know state by state, it definitely varies in what's sort of the norm or the common practice. But I love the fact that our office will accept a certified check at closing, because then I know it's in their hands and not like.
We're seeing so much of that here in Texas. A lot of it's the title companies are the ones that do all of that here instead of attorneys' offices. And so the title offices, they will receive money, but they're having people come in and pick up checks now instead of doing those wire transfers. So they said there's just too much fraud going on. And they said with AI being so intelligent in terms of how it's working at the moment, they're like, we're just come in and pick up a check. And so the last month or two, that's what we've moved to here. It's a little crazy.
We had a transaction. AI like adds another layer that is just so crazy. But we had a transaction recently where, from our standpoint, if you have wiring instructions, we need it to be an original. When we're representing the buyer and we're going to wire out funds, we need an original wiring instruction form with our whole thing filled out. And then we also do a callback verification to make sure that whoever's written on that form, we're verifying that the information is correct. So it was interesting, but thankfully we had that protocol in place, but not all offices do. So there was somebody who called to verify, and I knew it wasn't I know the attorney very well. And he called to verify instructions, and he said he was XYZ attorney. And I'm like, no, you're not him. You're not him. He was calling to verify and to change instructions, and it was a fraudulent, it was, someone. It was crazy. But thankfully, there are those protocols in place, because the likelihood in that situation, they would have been giving me other information, and I would have said no anyway, because our wire instruction sheet is clear that we will not accept change of wiring instructions. So this is what you got. If not, you're going to hand deliver a different copy, right? So it's crazy out there. It's really scary. But thankfully, I think because our concern for a lot of people when we represent sellers was that, the change of this going to default to checks now, that our sellers would be really kind of frustrated, because it's always been the case that you can get funds wired. As soon as it hits your account, they're all good funds. You don't have to wait for them to clear, right? And so we were really concerned that a lot of our seller clients would be really, really upset about, again, we have no control over it. It's whoever the buyer's attorney selects, or whoever the buyer's attorney is, their office has the ability to dictate what they want to do. But thankfully, sellers have been very, very reasonable in understanding the risk associated with it, and have been but again, it's expectation setting. So whenever we talk to a seller, we tell them from the beginning, hey, by the way, I know that probably when you sold in the past, this is what happens, but that's kind of not what's happening anymore. There may be a situation where the buyer's attorney will cut you a check instead. So things are changing in that regard for sure.
At least you've got those procedures in place, and thank goodness for attorneys to help protect the process. So
it's scary out there with that stuff. It's just, but paper is king for a reason in some situations.
I love that. I would love to get your input on contingencies. I have several clients right now that are only wanting to do contingencies. So my question is it's two-part. Number one, would you recommend doing a contingency? And the second part is, what are some things that my clients should watch out for while doing a contingency?
On the buying side, your buyers.
Yes.
Yeah. So it's interesting because I still, how sometimes clients, you just remember certain things about their details. I still remember my first waived contingency for a mortgage contingency where I knew my client was getting a mortgage. I still remember it. I know like their name. I know that house.
There's no way to forget any contingency.
No, it's so funny because that transaction, I was so scared that my client was going to lose their deposit because they didn't get, because it was about 8 years ago. And like, it was the first time I'd seen someone waive an inspection for a mortgage contingency. And I was just like, how are you putting, all of this money on the line? Are you sure you're going to get this mortgage? Like they were fine. The lender was like, no problem. But I was like, sweating bullets as the risk averse, attorney. So it's becoming very, very commonplace to waive. But again, my default is always having it because, I'm, again, from a perspective of an attorney, everything is about risk mitigation and minimizing risk in any respect. And so for me, especially I think during that 2020 to 22, it was so, the market was so insane that at least in Boston area, everything was waived. You were waiving inspections, you were waiving your financing contingency, you were waiving everything.
Here as well.
I didn't like it. As an attorney, it just obviously it makes the deal go faster. So we weren't, having to negotiate anything after inspection results. Every transaction seemed to go faster as a result of that. But I just also know how many clients were later kind of a little heartbroken where, something that would have easily come up during an inspection came up and, they were already paying top dollar for the property and they didn't have, as many resources as they should have or wanted to have had for things that came up that, again, could have easily been resolved as a result of an inspection. So again, from my perspective, I like contingencies because it gives the buyer an opportunity, depending on what it is, inspection or financing. From inspection, it gives the buyer the opportunity to really have their eyes wide open. We're a buyer beware state in Massachusetts. So the only thing the seller has to disclose is whether there's lead paint or septic system. That's it. Everything else, you don't have to disclose as a seller. If you're asked a question, you can't lie, obviously, but those are the only two required disclosures. So there's a lot of room for potential issues for a buyer.
So when you say buyer beware, does that mean that you should, as a buyer, you should put together a list of questions that could come up that they're not legally required to disclose, and just say, I'm asking all these questions just so you don't lie to me?
Yeah, no, I think it's a great point. So there's even the seller disclosure form. I don't know if you all have those in your states where they kind of answer a bunch of questions anyway. So those we try and incorporate into the purchase and sale agreement, but those again are not obligatory. As it's when I'm representing a seller, I tell them not to sign one, because I've had situations where I've represented a seller who did everything that they want, were very, very truthful in their mind of what happened. They forgot one thing. And of course, something happens as a result of it. And because they signed something on the seller disclosure that ended up not being correct, they ended up having to pay to resolve that thing. Mm-hmm. So, and I knew it was like an innocent, sometimes you just forget something if you've lived in the property for a while, So again, that's the perspective of who you're representing. Obviously, like I would favor my client in that respect. If I were representing the buyer, I'd be like, yes, But at the same time, it's not obligatory. So, but yeah, I always encourage, and also in the purchase and sale agreement, we do present things that we are having the seller represent regarding their knowledge of the property to kind of vet some of that stuff out as well.
Yeah, they're
But
just so
sorry, I don't know if I answered your question completely, but basically, contingencies I look favorably on just because I think it's the fair thing. But when you're representing a seller, it is kind of difficult when you have the option of no contingencies, and then you have someone with a contingency. Obviously, no contingencies where it's at.
Well, I think the important thing is there are just so many moving parts in a real estate transaction. And as a home seller or a home buyer, investor, whatever approach you're taking, you really do need to surround yourself with professionals that you trust, that you feel like you have open communication with, and who are looking out for your best interests. I'm glad in North Carolina that part of that for me involves having good real estate attorneys and their teams. But I think we've all learned some great information to anticipate things coming up in a real estate transaction. It's almost inevitable. And to have a backup plan and have people working for you on your side that can help you come up with creative solutions to that. So we really appreciate you sharing all that information with us, Liz. I know I learned a lot.
Thank you. I so appreciate you all having me on. It was great to learn a little bit about your states too. And, you know, anticipating things, I think, is the key, and making sure your client is aware of potential issues that could pop up. It just makes for a great transaction at the end of the day.
That's fantastic. Let's go around the room and let everybody in our audience know where they can find us if they're looking for a good real estate attorney or realtor, or if they need a fantastic advocate for move-in, move-out cleaning for their home. I'm Brooke Bryant. I'm in the Charlotte, North Carolina area. You can find me on all the social medias at Ask Brooke Bryant. Aaron?
I'm at Ask Aaron Brown. And you can find me on all the social medias there. I'm based out of San Antonio, Texas, and would be delighted to help you.
Regina?
I'm Regina Brown, also based out of San Antonio, Texas. You can find me on all of the social medias at Regina B Realty, and I look forward to helping you all out.
Great. And Angela?
I'm Ask Angela Brown on all of the social medias. I'm Angela Brown, the CEO of Savvy Cleaner, and we help house cleaners and maids to help you get your property ready for selling or buying, depending on which side you're on. We help you with the cleaning part.
Fantastic. And to our wonderful guest expert and real estate attorney, Liz, if you'll tell everybody where they can find you.
Yeah. So our website is easyligris, ligris.com. My profile is there. I'm on Instagram at LizBESQ, and my email is barlettateam@ligris.com. But thank you all so much for letting me chat today with you all.
Liz, it was so insightful. Thank you so much.
Thank you. I appreciate it.
And we'll see everybody again next time. Have a great week.
Bye.
Thank you all so much.